Welcome to this webinar, Getting GDPR Compliant, a very hot topic for today. Thank you for joining us. And today we have the chance to have three experts on the domain. First, let me introduce you Mr. Guillaume Taillez, which is Product and Training Manager from MGK Technologies, specialist in the ESET products. And he will be accompanied by Sabine Mersch and Jocelyne Calumet from LCM. So both are privacy and legal experts. And so today we'll cover different topics. We'll start with Jocelyne. She will introduce you to the theoretical topics. First, she will cover the issues and interests of data protections. She will cover an overview of the global legal framework on the GDPR and an overview on the new obligations of the GDPR. Then Sabine will cover a practical illustration of what Jocelyne showed. You have, of course, the opportunity to ask questions, and we have a session to answer those questions just after. We will ask you as well some questions to have your view, your input. And then we will have the presentation of the encryption solution from Guillaume Taillez with a demo. And we will end this webinar with some practical conclusions. And if we have time, we will try to answer your questions. So thank you. Now it's the time for Jocelyne to present the first part.
Thank you. Hi. So the goal of this presentation, as the name indicates, is to show how to get GDPR compliant. But because the subject is really wide, we will only talk about some key elements. And please note that this presentation is a summary of a white paper that we have drafted. So do not hesitate to read it if you would like to learn more about this topic. Data protection is a central issue because we all transfer almost daily personal information about us to the rest of the world. For example, with social media or by using a cell phone. But we often have no control on the organization to whom we transfer this data. And on top of that, there are more and more cases of data breach, as for example, hackers. The European legislator has decided to react by increasing the responsibility of the different actors involved by adopting fines up to 20 million euros, or 4% of the total wide world turnover. Now, very quickly, the legal framework. The protection of personal data really is a fundamental right enshrined by the Charter of Fundamental Rights of the European Union. And since 1995, we have, regarding data protection, a European directive that has been transposed in the different member states of the European Union, but in different ways. And the result is that we now have 28 different national laws. So the GDPR aims at correcting these weaknesses of this regime. and the GDPR is in force since May 24, 2016, but will only apply from May 25, 2018, so that the organizations have time to comply. The main objectives of the GDPR are to simplify the law. So from now on, there will only be one regulation. What's more, will be directly applicable. There is also a desire to extend the scope of this legislation to every actor that reaches people in Europe, which means that even American companies and companies all over the world are concerned. And generally speaking, the objective of this regulation really is to find the right balance between the opportunities of digitalization and the risk of harm to data subjects. The key concepts of this regulation are processing and personal data. Processing means any operation performed on personal data, for example, recording data in a CRM. And personal data means any information relating to an identified or identifiable natural person. We call that person data subject. And that means that even if a person is not identified but might be, then the definition applies. It is, for example, the name and address that is collected through an online form, but it is also, for example, the IP address that is collected during the visit of a website. The new obligation under the GDPR now. There is two levels to consider. The processing level as in the past, and the level of the entire organization, which has been introduced by the GDPR through the concept of accountability. And here you can see the resulting specific obligations. I'll let you watch a little bit, and then we will develop some of these obligations. At organizational level, there is firstly the obligation of maintaining a record of processing activities. Organizations that have less than 250 employees and process personal data with no risk, or process non-sensitive personal data, or process personal data occasionally, are excluded from this obligation. But what I can tell is that very few organizations are excluded from this obligation, because as soon as you at least have employees, then you process data non-occasionally. There is also the designation of a data protection officer, the DPO, which is mandatory in certain cases and recommended in all cases, because the DPO will have a facilitating role in relation to these new obligations, obligations of the GDPR. The data protection impact assessment allows to identify the extent of the risk and the measures to reduce the risk. Concerning this notion of risk, we just got guidelines from the authorities that tell us when there is a high risk. And the GDPR not only tells us that the security measures that we take must be appropriated to the risk, but it also gives examples of appropriated measures, as for example encryption. And one of the major interests of encryption is that it permits to not notifying a data breach to the data subject, which is a huge advantage.
Thank you, Jocelyn. Now Sabine will go into more practical.
I think Jocelyn just drove us through the different provisions and obligations which apply at organizational level, but of course each processing also needs to be made compliant as such. And in order to do so, we are at LCM using for several years the Europrice methodology. Europrice means European Privacy Seal. So it's a certification which has been developed by German data protection authorities in relation with the European Commission. And the advantage is that it translates the provisions of the former directive or the actual directive and the future regulation into a limited set of some 50 compliance criteria applicable per processing, and those criteria are then divided in 4 blocks. The advantage of using these blocks is not only to summarize the criteria while still being sure to have a look at all of them, but also to divide who has the lead in terms of organizational responsibility for compliance. So first of all, we have the fundamental principles, and I will go so that as in the example in a few minutes. What is important there is to define the flows, to define who is who, and to see whether some basic principles like data minimization, purpose limitation, etc. are respected. The second very important thing to verify is whether the processing is indeed established on a legal basis. And this will interest those who are dealing with security, so the technical people. These are more involved in the third-part security measures. And then lastly, the rights of the data subjects, which is really a topic which needs to be addressed by both legal and technical people. So let's now try to illustrate this, all the different obligations with the following practical example of a car dealership, a car dealer who has several subsidiaries and who would like to put in place a CRM, including information about prospects and clients. So clients would be typically either contact persons of companies to which the car dealer has sold cars, or then individual consumers who have bought their cars at this car dealership. And then prospects would be more people who have provided their data to the car dealer on the car dealer's website, for example. So as I said, the first thing to do is really to see who is who and to apply the necessary legal qualifications to all of the parties involved. Most important thing is, most important topic or qualification is data controller. Why is the car dealership qualified as data controller? Because it's the car dealer who has decided to put in place this CRM and who has chosen and who has selected the service provider who will help him to put this in place. So the car dealership would just be the data controller. The supplier of the CRM who will act on behalf of the data controller and who will put effectively the security measures in place to secure the CRM will be qualified as the data processor. The people about whom data is collected in the CRM will qualify as data subjects, and companies or parties to which data will be transferred and who may access the data for their own purposes will qualify as third parties, and this will not be the case for certain or all subsidiaries. So now that we have established the context, let's have a look at whether which fundamental principles need to be respected. Of course, we have the accountability principles, which Jocelyn just outlined, which mean that you need to have a register, maybe a DPO, etc. So these ones have already been elaborated. So let's now concentrate on the others, which apply to this particular processing of CRM. So first of all, we will have to make sure that the data processing is fair, meaning that that no data are collected about the individuals without them being informed about the collection. We need to ensure that the purposes are limited, meaning that at the moment of collection, the purpose is clearly established and articulated, and there are, for example, in our case, probably two purposes for the CRM. One is to ensure that the contracts with the different clients are well executed, for example, in terms of maintenance. The other purpose is probably to get in contact with prospects or clients for marketing purposes. So there are already two different purposes for which data might be collected, and those two purposes need to be set out at the moment of collection and need to be respected. Data minimization means that no more data should be collected than those who are really necessary for the purposes. And accuracy of personal data means, of course, that the data controller needs to ensure that that he actualizes the data at regular intervals in order to be sure that the data he's processing are always accurate. Then in terms of storage limitation, it's also necessary to limit the storage of the data for as long as necessary for the purpose. So you will see that the definition of the purpose is really important as of the beginning of the processing. And yes, of course, you have integrity and confidentiality, which mean that nobody who has that only people who have a justified reason to access the data may indeed do so. Then let's go to the second building block in terms of compliance, so which is the legal grounds. So there are different compliance criteria who are summarized in this block. The most important one is really to ensure that there is a legal basis, and so there might be different legal bases possible. In our case, it's most likely two possibilities. The first one is the contract with the client. So every processing which would be necessary for the purpose of executing that contract could be justified by that contract. So no need for further consent. While for the marketing purpose, there is no contract. So there would be a need to obtain a valid consent. And what does it mean, a valid consent? A valid consent is one who is free, specific, informed, and unambiguous. And this unambiguous, for example, means that people need to have a choice. So you cannot just have a box to be ticked on a website in order to provide consent, and which is pre-ticked, but you must leave the choice to the person, so the person might not tick the box. Also, informed means that you need to inform the person before it provides the consent about the consequences of providing the consent, so notably about what data are collected and for what purpose and to who will have access, etc. These obligations in terms of transparency are very much increased under the GDPR, who really is against these very lengthy privacy policies which nobody reads and nobody understands. In contrary, the GDPR now really requires you to be very transparent and use very simple and plain language. In terms, so let's now go to the third portion of compliance criteria, which are linked to technical and organizational measures. So as Jocelyn pointed out, those technical and organizational measures need to be appropriate to the risk. So that means that you have to know about the risk. Risk means risk in terms of vulnerabilities of the data being breached. And so in order to avoid this and avoid any risk for the data subject, so we are really looking here at the risk for the data subject and not at the risk for our garage, for the data controller. So in order to ensure that the technical and organizational measures are really appropriate, we need to make a risk assessment. And then once this is done, then ensure that appropriate security measures are implemented. And as we will see, encryption is one of the measures which is recommended by the GDPR in certain cases, and which has also some positive effects in terms of reduction of notification obligation to the authorities and to the data subjects concerned in case of data breach. So in order to secure or to reduce the risk, encryption and technical security measures are one thing to be done, but there are also legal measures to be taken, like, for example, data controller processor agreements. And I think in this respect, there is really a shift of paradigm in the sense that so far, under the directive, only data controllers were obliged to comply with the obligation to put in place a controller processor agreement, while now under GDPR, both the processor and the controller are obliged to do so. Which will, I think, increase the amount of controller processor agreements put in place dramatically, because the GDPR also provides that if no contract is put in place, and if there's a data breach, and if a data subject would be harmed, then that data subject, so that individual whose data are out in the public and who has suffered some damage, might then sue both data controller and data processor, and if there is no contract in place who outlines the respective obligations of both of these parties, then they are in trouble. So I really recommend to put in place this kind of agreements. You have to note, and this is, I think, also facilitating the work, is that now GDPR is very detailed about the obligations to be put in place in the contract. So there are some minimum clauses which need to be included. Another very important point also when it comes to contractual measures is that you need to take into consideration who the data processor is and where he is established. For example, if your CRM provider is also using a cloud provider like Amazon, who is established in the United States, then this has some impact on you, because you will be responsible for the fact that data are transferred outside of the European Union to countries which are considered by the European Commission as not providing sufficient security guarantees. And so in order to allow such transfer, certain contractual provisions need to be put in place, unless, for example, it is the case, as it is the case with the US, there are some other mechanisms who exist, like the Privacy Shield, which you have probably already heard. Privacy Shield, which is a mechanism or an agreement put in place between the US and the European Commission, which allows companies, US companies who are Privacy Shield certified to receive personal data from European companies without any further accommodations. Then we come to the first block of data protection requirements from a compliance perspective, meaning we have to ensure that data subjects' rights are respected. As mentioned before, the right to be informed is a very important one, but there's also one which already existed so far and which could have quite some important effects on you if you are not prepared, like the right to access. So what does this mean? This means that if you are collecting data about an individual and store it, for example, in your CRM, and that individual might come to you at any time and ask, please tell me what type of data you are collecting about me. And if you are not organized, this might be difficult because you also have a certain delay of 30 days to respond. So please be prepared. And there are also some new rights. So, for example, the right to data portability, who does apply in certain cases whenever the data processing is based on a consent or a contract with the data subject, and gives and entitles the individual to receive data collected on a media which is compatible with another data controller or service provider to which you would like to transfer data. So there's a need to ensure that you know about the data, about the rights the data subject could exercise, and that you are prepared in terms of organizational measures and processes, for example, with your IT department, in order to be sure that I can actually respect and answer the people who are exercising those rights. Yes, so in terms of recommended actions for this part, please put in place procedures, and in any case, make sure that you have the necessary privacy notice, because that one will be required in any case.
Okay, thank you, Sabine. It's now time for question and answers. But before going into answering the questions, let's ask questions to you, the participants. So first question we'll ask you is, have you identified your processing activities? So you have 4 choices. First answer is yes, second no, or I don't know, or I don't understand. So please respond to the poll now. So we're waiting for the answers of the participants. So please answer to the questions. Yeah, answers are coming. Still waiting for some seconds. Some more answers. Okay. Second question. The second question we'll ask you is, how do you secure personal data? You can answer yes with encryption, yes with access control, other solution, or I don't know. So we are waiting for answers. Some are coming. Yeah, answers are coming. Everybody voted, so thank you for being so quick. And the next question, so we have 5 questions in total. Next question is, are you data processor, or data controller? Do you consider you as data processor or data controller? So you can answer yes, data processor, yes, data controller, or sometimes data processor and sometimes data controller, or no, or I don't know. So waiting for the voters. Yeah, we are almost done. Yeah, everybody voted. Thank you. So now, next question. Do you have any information notice, so privacy notice, on your website? And the possible answers are yes, no, I don't know, or I don't understand. So waiting some seconds for everybody to vote. Now we are done. And the last question, do you have data processors or third party outside of the European Economic Area? Possible answers are yes, no, I don't know, or I don't understand. So waiting for the votes. Waiting for some seconds. Thank you for being so quick. And then we are done. So let's have a look now at the questions we have. So the first question we have is about the privacy notice. So the question is the privacy notice as the same of the confidentiality policy or the privacy policy?
Yes, I think the answer is very easy, so it's yes. So any kind of document, however you name it, which you put on your website, who informs individuals or visitors of the website about what type of personal data or data you collect about them, including for the use of cookies, for example, is considered by this privacy policy document.
Thank you, Sabine. Another question on the UK and the Brexit. So do we have to consider UK as within the European area, or is it considered as outside now because of the Brexit?
I think what will happen is that we will have to see how the European Commission reacts. For the moment, every feedback we have seen is that the UK wants to be a very good element, so they want to comply with GDPR, even though GDPR might not directly apply to them. So I think it's unlikely that the European Commission will consider the UK as being not sufficiently protective of data protection in order to be considered as a secure partner. But you never know, and I think what to do in order to address this kind of risk is to include an annex in the controller processor agreement. You will need to put in place with any processors established in the UK or elsewhere, in order to make sure that in case the data processor or its sub-processor moves to a country which is not considered as providing sufficient protection, that then you can activate standard contractual clauses which could already be annexed to the controller process agreement.
Okay, thank you, Sabine. We still have some questions, but we will wait for the end of the session to proceed. So let's go now into the encryption solution and the presentation from Guillaume. So Guillaume, you can present the encryption solution.
Yes, I can do. Hello. So here our concern will come after the analysis of the risks, which has to be done to know what kind of solution, technical solution, we have to perform to be compliant regarding the GDPR. So here, for example, we'll have some data available on a network and on a local computer. This computer will be also a laptop able to move outside of the office. So we will need to secure the access of the data, not only the access but the data itself regarding the GDPR. For it to not be available for any person who will be able to either store or to have access to the data, which is not allowed to have this access. So in my example here, I have a shared folder, and on this shared folder, I will have an encrypted area. So this encrypted area, into this area, I will have my data secured because it is encrypted. I will also have on my folder, on my computer itself, encrypted area as well to secure the data I want to use on my local computer. So the access of the data will go through Desktop, the program which will manage the encryption process. And with this program, for example, here, I will have access to virtual drives. So I have several drives. So here, those drives are locally on the computer. So encrypted area are locally on the computer, and this one is on a shared folder. So I have just access to this drive through encryption keys. And this example here, you see I have one folder, one encrypted area, which is grayed out because I don't have the right to access it. It means that I don't have the key, the encryption key to access to this encrypted area. Here, just to open an encrypted drive, I just go here, I mount it. Let's say, for example, here. And automatically, I have my encrypted folder, which is available, and I can have access to the data in this folder as I wish. My shared folder is the same here, and now I will just log out of the program, and as you can see, my encrypted folder, which was here S, for instance, is no more available. I log in just to show you. Log in, and my folder will come back here as well automatically. It's just a setting to open automatically the folder upon login. So this is just for a folder. Now I will just show you how to manage this famous encryption keys, which is the core of the system. Everything is performed by the enterprise server here, for instance, just central administration. I will just share encryption keys to different users. So here, for example, I will just add some encryption key to this user. I will perform a synchronization of my key, and now I just come back on my program and resynchronize here. system updated, and if I open back the disk manager, you can see here I have access to this folder now, to this encrypted area. We'll just mount it to show you. So as you can see, I have now access to the data in this area. Well, this is for the local computer to have access to some data in the company, but this computer, this user wants also to share some data to other people outside of the company. So for this, you can use encrypted email. With another complement, you will just encrypt your email and be able to send encrypted email to your correspondent, and you can as well use some encrypted drives, and the other person does not need to have the disk solution installed in this company. You will just have the right, will give him the right to access to the data. Here, for instance, I have a USB stick plugged on the computer. On the drive, I don't see any data on the stick. I just see an executable file just to give me access to the encrypted data. I just click on it. I just show you here. I need to write my password. Should be this one. Yes. And now I have access to my data on the USB stick. So I don't need to have the desktop program installed on this on the other computer. I just need to know the password for the access. Once I don't need the data anymore, I just quit it, and that's it. My data is still secure on the USB stick. I can lose the stick. It doesn't matter, because the data is still encrypted and not available for anybody, unless you have the password. So the password is not shared by default to everybody, of course. Encrypting the data is something very important regarding the GDPR. In case of any loss of data, or if your data is stolen, you will not have to tell to everybody concerned with this data loss that there may be a risk for their privacy, because the data is not available, it's encrypted. So you don't have to tell to all concerned people that there maybe have a data breach. There is no data breach here. And also, as well, you may not have to tell this data breach to the local authority, because the risk is not present, as the data is not available to the thief. Another possibility here, I will show you. I will just restart the computer. Just to show you, my computer itself is encrypted as well. So if I lose my laptop, or if stolen somehow, any data on the computer itself will not be available, because the drive is totally encrypted. So just before I have access to Windows, before my computer starts to run, I am asked for my credentials, so password, user password here. This one. Yep. and now I have access to my computer and I can work as usual. There is no difference to work with this computer if it is totally encrypted or not. No, just at about seconds you will have to write your credential. Okay, those were some features of the Desktop project to show you the capabilities and the power of encryption. It's very important to have your data secured. And to secure your data regarding the GDPR, encryption is very important. Thank you.
Yeah, indeed. And in general, it's very important to protect the data. Thank you, Guillaume, for this nice demo. Now we'll go into analyzing what you answer to the questions. So let's see. The first question was, if I remember correctly, have you identified your processing activities? Let's show the results. So the result is 100% no. It's interesting.
Yeah, I think I can understand that for small business who have probably other things to do than that. But I think in order to address GDPR properly and be sure that you have the right scope for your efforts, it's always interesting to identify processings, and this can be done quite easily. I mean, if you have some employees, you will probably have data which you collect or which you process for the purpose of paying those employees. Then you might have a website which collects personal data, and so those two would already be two processings. And the only thing you then have to do in order to further comply with Article 30 and the obligation for most companies to have a register is just to add some details per processing which are provided which are provided by Article 30, like the type of data which are concerned, the clear specification of the purpose, and again, who is who, so who is data controller, who is data processor, etc. So I think it's worth to be done, and it's not a very difficult task.
Okay, thank you, Sabine. Second result. So question was, how do you secure personal data? So do you do it by encryption, by access control, or the solution? And the answers are, a third of the people do it by encryption, and majority do it by with access control.
I think this is a very positive result, since I think you will probably need both.
Yes. There is, from the result, there is an access control. This is great. Now, the best solution would be to use both solutions. To access control, normally access control with login by Windows shares, file shares, or so on, and access control to secure area by login user password. Yes, this is great, but we have to go further now with GDPR also, to not have our data available in case of any loss or anything which will be stolen. So encryption will come in addition to the standard access control to secure the data and to not have it available in case of any data breach. If somebody is stealing your USB stick which is encrypted, these people will not be able to read what is on the key, for example.
Okay, thank you, Guillaume and Sabine. So this is for this question. Next question is, are you a data processor or data controller, or maybe both? So what's the result of your votes? So a lot of people answered, I don't know, 2/3 of the people, and one answered sometimes data processor and sometimes data controller, 1/3 of the people.
So I think it's worth to restate the definition. So the data controller is the one who, in legal language, determines the purpose and means. So that means the one who initiates the processing, so who decides that this processing is going to happen. For example, the employer in terms of processing of employee data, or the garage who initiates the CRM, because it's the garage who has decided that this CRM is going to happen or to be put in place. And then the data processor is clearly the one who is acting on behalf of the data controller. So that means that he is acting based on instructions from the data controller. So that means that in terms of security measures, for example, it's the data controller who needs to decide which types of security measures must be put in place, and then it's the data processor who needs to implement those. So the data processor is clearly the one who is acting based on instructions of the data controller. And for the third of the people who have said sometimes data processor, sometimes data controller, I think that is a very likely situation to be in, because if you're having employees, you will be data controller, and you might also process data from your clients, for example, for client purposes. And so that means that in such cases you would, as part of your services, for example, be a data processor for your clients. So I think this is a very likely situation to be.
Okay, thank you, Sabine. Next question is, do you have an information notice or privacy notice on your website? So what's the results? So we have different answers, yes, no, and I don't know.
So we have them all. I think that's also quite common that companies don't have privacy policies or privacy notices on their website. But I think in most cases it's necessary to have one, because in most cases you already process data via cookies. And there are not many websites which do not have cookies, because most of them already use Google Analytics. So I would really encourage you to put a privacy notice on your website, unless you really have neither any contact form nor any cookie on your place via your website.
Thank you, Sabine. And then the last question, do you have data processors or third parties outside of the European Economic Area? What was the answers? Yes and no.
I think that's positive, because apparently it's very clear to everybody. Just for those who have voted no, I would just like to clarify that as mentioned, you do not have just to have a look at your first, so your immediate service provider, but you also have to ask that service provider whether he doesn't use himself subcontractors outside of the EA, because you will be, as data controller, responsible for both. So you really need to make sure that you know where the data will finally end up. So if your data processor or your service provider who's sold the CRM to you will use, I don't know, data centers in India, that means that you will be responsible for the processing performed by those Indian companies, and so you really need to ask your processor, and in case of doubt, it might always be useful to use European-based processors.
Okay. Thank you, Sabine, sorry. So now let's go more into the questions. Still, we have some questions left. One is for Guillaume about the Desklog solution. Is it the Desklog solution certified?
Yes, it is. I don't have in mind the certified number, sorry, but yes, it is certified.
Okay. And does it to be a data processor? Is there any particular certification to be recognized as GDPR certified data processor?
There are indeed certifications which exist, and under GDPR, these certifications will even provide further advantages. For example, Europress is one certification which exists for processing. But there will sure be others, and the good thing on the GDPR is that the Commission will accredit those certifications so that people can be sure that the certification is something qualitatively high.
Okay, thank you, Sabine. Maybe last question. If I'm a webmaster and using Google Analytics, do I have to inform the visitors of the websites? What do I have to do?
It's not for me as the webmaster to do that, but for the website owner via this privacy notice, which will provide not only information about personal data collected directly or indirectly, but also probably be used to comply with the information obligations of the e-privacy directive.
And yes, maybe we still have one question just came, or two questions, so we still have 1 or 2 minutes. Is one question for Guillaume: is two-way authentication necessary by GDPR when encrypting data?
This is something different. Two-way authentication will provide a more secure way to access to a given chair or a computer or whatever. But once you have access to the computer, you have access to everything which is accessible from this computer. The data itself can be stolen in any other way. If you steal the hard drive or a hard drive on a server or a USB stick, two-way authentication will do nothing because you have physically access to the data, so you can bypass a lot of things, including two-way authentication. But if you encrypt your data, you will not have physically access to the data itself. It will be secure, the data. So two-way authentication is not necessary. It's a good complement for authentication for the use of the data, but it's not something regarding the GDPR. Encryption will be a lot more useful in this. But to avoid any data breach, yes, two-way authentication will be great for the data breach. To avoid the data breach. Yeah.
Okay, thank you, Guillaume. It's now time for the conclusions. So if we, yeah.
I think everybody will agree that data protection and the GDPR and compliance with it is important to reduce risks, especially in terms of sanctions and fines. However, we have realized with our clients when doing data protection compliance projects and notably making inventories that the fact to know where your data is and the fact to know how you pose it for what purpose, who has access, etc. That this has proved to have very important benefits in terms of data governance. And another thing is also that there are several polls and studies who have been made recently who show that consumers have, it's important for consumers to be sure that their data will be properly protected. And so I think in terms of consumer and customer trust, data protection is also an asset. In terms of actions, we really recommend to establish a compliance program. This must be, of course, tailored to the size of your company. As I said before, having a mapping of processing activities can be a big or small exercise depending on the number of processing activities you have, but in any case will be useful in order to determine the scope of the burden. And so I think that's something I would recommend to everybody. And besides that, there are also two other things from a legal perspective, two other measures from a legal perspective, which I think are important, despite for everybody, so because they are important for all types of processing, is to have a proper privacy notice, so informing, which is a template which you can use then as a tool for any kind of privacy notice which you have to make. And then a controller processor agreement, because I think almost every company is outsourcing part of its data processing to third parties. And so having in place this controller processor agreement can provide a big advantage in terms of risk for the company, because this document will allow to split responsibilities and to put responsibility where it belongs. And then, of course, in terms of IT security, we would recommend to make a risk assessment and then integrate encryption, for example, in an appropriate manner.
Thank you, Sabine. Thank you, everyone. This is the end of this webinar.
Thank you.
So after the webinar, you will receive some materials like the white paper edited by ESET on GDPR. This presentation in PDF format. You can access, of course, the recording through your GoToWebinar application. And if you want to evaluate your readiness, your GDPR readiness, the readiness of your company, there is an interesting link that we will send you as well by email, a survey that you can do online to check where you are regarding GDPR compliance. So that's the end of this presentation. And thank you, everyone, and I wish you a pleasant day.
Thank you. Have a nice day.
Bye.
Bye.